Well, hey there, all you cool cats and kittens. This is your lecture video for assignment number 35, in which we will begin talking about modern substantive due process. So, after the demise of the Lochner era, the Supreme Court no longer recognized the freedom of contract as a right that was protected under the liberty provision of the Due Process Clause. But the court does continue to recognize other rights as being substantive rights that are protected by the due process clauses of the 5th and 14th Amendment. And most of these rights center around a concept of a right to privacy, by which we mean a right to make certain types of intimate decisions without government interference. And these decisions can include things like making choices that relate to the raising of children, about marriage, about reproduction. They can be about the right to make personal medical decisions. And the question that is raised, continues to be raised by this use of substantive due process, is whether or not the court should be in the business of recognizing these types of individual constitutional rights. And if so, how do they determine what those might be? So we start out this chapter by returning to this issue of fundamental rights. So we know that the due process clauses protects our liberties, but it raises the question of what are these liberties? The Lochner Court protected freedom of contract as one of these liberties, but did it have the authority to do so, or should it have? Where did this idea that freedom of contract was a constitutionally protected right, and indeed a particularly important constitutionally protected right, where did that come from? So we might have all sorts of liberties that we think the government shouldn't be able to interfere with, at least not for just absolutely no good reason, for no rational reason, right? The freedom to be able to eat popcorn on any day of the week that we want to. And these are certain types of liberties that we might protect under a form of substantive due process, but we would only apply a low level of protection, a rational basis scrutiny, we call this. Simply ask to see if what the government is doing is rational or ensuring that it is at least not arbitrary. But as we've discussed, there are other types of rights, other types of liberties that we have determined are more important and where we think the court needs to scrutinize what it is the government's doing, the government's justification, even more closely. And these are the liberties that we refer to as fundamental rights, and they have special constitutional significance in that they trigger this higher level of scrutiny, which we refer to as strict scrutiny, whenever the government interferes with them or burdens them or discriminates among us in relation to these rights. But we still have this continuing question of what are these rights? How do we know which rights we have that are fundamental rights? Now, some fundamental rights have a clear textual basis. These are the rights that we find in the Bill of Rights: our right to free speech, our right to freedom of religion, the fundamental rights that the court incorporated via the Due Process Clause of the 14th Amendment to apply not just to the federal government, but also to the states. And in that important footnote that we looked at in our last class, footnote 4 of Caroline Products, the court talked about how these types of rights, these rights that we find in the Bill of Rights, are the type that should get this heightened level of scrutiny, this more exacting judicial scrutiny. But there are these other rights, as I've been talking about, the rights under the right to privacy that the court recognizes as fundamental rights, even though there is no clear textual basis. And this is going to be the focus for our last couple of class here. So the question is, how should the court decide when an unenumerated right is a fundamental right? And One way that the court might decide both that it can recognize unenumerated rights as fundamental, but also how, might be to look to the Ninth Amendment. The Ninth Amendment tells us that the fact that certain rights are listed for us as being protected in the Bill of Rights in the Constitution shall not be construed to deny or disparage that there are other rights that are retained by the people. Now, during the drafting and ratification of the Bill of Rights, there was a battle between the Federalists and the Anti-Federalists over whether or not the Constitution should include a Bill of Rights. On the one hand, there were those who said that, of course, these were very important rights and we needed to secure their protection by explicitly mentioning them in the Bill of Rights. And on the other side, there were those who were afraid that by merely listing certain rights, we were going to run the risk of saying that these were the only rights that the people had. It was also believed that because we were creating a federal government of limited powers, including a Bill of Rights was unnecessary because the federal government simply would not be able to do that many things. So Alexander Hamilton made this point in Federalist 84. He asked, "Why declare that things shall not be done which there is no power to do?" The Ninth Amendment was a compromise in this battle, but it's a little unclear what exactly the Ninth Amendment does. Is it itself a source of a right? Do we have Ninth Amendment rights that the Supreme Court can recognize and protect? Does the Ninth Amendment provide a justification for judges to be able to protect certain rights that could arise within a constitutional framework? Or does it do neither of these things? Much like the battle over the 10th Amendment, is the Ninth Amendment merely sort of a reminder to us that we have other rights, but these other rights simply aren't constitutional rights or what today we would call fundamental rights. So fundamental rights are primarily protected in two different ways. We're only going to be focusing on one of these here, but I wanted to briefly mention the two different ways just so we can have an understanding of the difference between the two, because they have a lot of overlap and we will see references to both of these in some of the cases that we will be talking about. So the first way we protect fundamental rights is through the Due Process Clause. This is our focus for our purposes here in Conlaw 1. Fundamental rights are also protected under the Equal Protection Clause, which is discussed in Conlaw 2 for those of you who will take that course. So the Due Process Clause is protection for rights, for fundamental rights, when the government is interfering with a right that applies to everyone generally. Example here arising out of cases, and I think the book uses this example, is that if we had a state that passed a law that had a total ban on the ability to sell contraceptives. The ban applied to everyone, and there's a question of whether there's a reproductive autonomy right to be able to purchase contraception, but it applies to everyone, so we would have a due process question. Equal Protection Clause issues are triggered whenever we have the government denying a fundamental right to some people while allowing it for other people. So we typically think of Equal Protection Clause issues being raised if we have an issue of racial discrimination or discrimination on the basis of sex. But Equal Protection Clause issues are triggered anytime we have the government classifying people and giving one group of people a benefit that they don't give to others, or applying a burden to one group of people that they don't apply to others. So the example here would be not that we have a state law banning the sale of contraception, but rather we have a ban on the sale of contraceptives to unmarried people. government separating people into two groups and placing a burden on one group or providing a benefit to some group, to another group. So most of these types of issues can often be protected under both clauses. They can raise due process clause issues. They can also raise equal protection clause issues. It really often just depends on how it's framed. There typically isn't any major practical difference because we apply strict scrutiny in either situation. If we are dealing with a burden on a fundamental right, although the due process clause has broader applicability since you don't need to show any kind of discrimination. But nonetheless, as I said, the analysis between due process and equal protection in these cases often overlaps. For our purposes, it's not really important. We're sort of taking it all in, but we're focusing on the due process clause. So I just wanted to flag that for you so it doesn't cause any confusion as you're reading these cases. The book goes through the analytical framework we use for thinking about cases that involve the deprivation or potential deprivation of a fundamental right. So we have these four basic questions that we ask, starting with the question of whether or not we are dealing with a fundamental right. So this, of course, is the million-dollar question. Whether or not we think we are dealing with a fundamental right can be informed by our view of the appropriate way to interpret the Constitution. Or if you are a cynic, perhaps you might think it's the other way around, that our view of the appropriate way to interpret the Constitution is informed by whether or not we think certain rights should be deemed to be fundamental. But it does raise these questions, right? Are we talking about fundamental rights that we think that were intended by the framers or the general intent of the framing generation? What things should we look to determine if we have a fundamental right? History or tradition? What are the tools that we should be using? Can the court look forward to where it thinks we are headed, or at least where it thinks the country and society is now? Or must it only look backward to where we've been? These are all the key questions of constitutional interpretation that we started talking about at the beginning of the semester that fall into this question of whether or not we have a fundamental right. It really is the key question, though, because if we determine that the answer is yes, then we apply this heightened level of scrutiny, strict scrutiny. If no, then we just apply rational basis scrutiny. This right here is Caroline Products footnote 4, where we have the two tiers of scrutiny, where we have certain types of rights where we're going to have this more exacting judicial scrutiny. We also need to know of whether or not we have an actual infringement of the right. If we have determined we have a fundamental right, then the right needs to actually be infringed in order to trigger strict scrutiny. Often this is very obvious, something like a complete prohibition. So for example, if we had a law that completely prohibited all abortions in a state, then we would have an infringement on what the court's determined is part of the fundamental privacy right and the right to an abortion, the right to terminate a pregnancy. But there are other cases where it can be less clear whether or not we actually have an infringement. Do things like, again, continuing with the abortion example, something like having a law that requires a waiting period before a woman can get an abortion, or spousal notifications, or limitations on the things that doctors can say to patients. Are these infringements of the fundamental right? Okay. Our third question then is whether or not we have a sufficient justification for the law. So continuing with our sort of two tiers of scrutiny, if we have a fundamental right and we are applying strict scrutiny, then we require the government to show that there is a compelling purpose for this law. But if we are only in rational basis scrutiny, we simply ask the government to have a legitimate government purpose in order to survive rational basis scrutiny. And then the final step is we take a look at the means. We do a means-ends test. We ask if the means are sufficiently related to that end. In other words, is this particular regulation sufficiently related to the government purpose that we identified in step 3? If we are in strict scrutiny, we require the government to show that the regulation in question is necessary in order to further that compelling government interest, to which the court often says it needs to be the least restrictive alternative, this particular regulation. But if we are in rational basis scrutiny, we need only to ensure that the government, that this regulation is a reasonable way to further that government's legitimate purpose. So for both sort of the means and the ends side of this test, we put an additional burden on the government if we are in strict scrutiny because we have a fundamental right. We're going to begin our consideration of the rights to privacy by starting with the right to marry, recognized by the court in the 1967 case of Loving versus Virginia. So this case was a challenge to Virginia's anti-miscegenation statute, which provided criminal charges to both people who were found to be in an interracial marriage. Now, this is one of those cases where we have a lot of overlap with equal protection, and indeed we study this case again in Conlaw 2, and the court in this case found that there was both an equal protection clause violation as well as a due process clause violation, but we here are focused for our purposes on the due process side of this case. So this case involves a challenge to this statute, which when it was first enacted was referred to as the Racial Integrity Act. And this law prohibited any so-called white person from marrying anyone anyone but another white person. And the statute defined a white person as such person as has no trace whatever of any blood other than Caucasian, but persons who have 1/16 or less of the blood of the American Indian and have no other non-Caucasian blood shall be deemed to be white persons. When I first started teaching this case, I found that part about the American Indian, the 1/16 or less, to be really interesting and sort of odd, and I was wondering why it was written this way. And when I looked into it, what I learned was that according to the historical records, this exception for persons with less than 1/16 of the blood of the American Indian was included out of a desire to make sure that all descendants of the marriage of John Rolfe and Pocahontas were recognized as being white persons under the law. Anyway, that's a sidetrack. But the court here finds that we have both these equal protection clause and the due process clause violation. And the court says we have a due process clause violation because we have a limitation here on everyone's freedom to decide who they want to marry. And the court tells us here that the right to marry, the right to choose the person you wish to marry, is a fundamental right, and it is protected as one of our liberties under the due process clause. And so the court says we don't have a sufficient reason to limit this based on racial animus, which is also part of how we get to an equal protection clause violation as well. But this was a due process clause claim in part because it did place a limitation on everyone's freedom to some extent on who they could marry. You could, if you were a white person, you were only allowed to marry another white person. If you were not a white person under the statute, then you weren't allowed to marry a white person. So everyone was affected one way or the other in that the potential pool of people you were allowed to marry was being restricted by this law. I also wanted to talk about one of the cases that's mentioned in the notes on page 956, the Zablocki versus Redhale case from 1978, also involving the right to marry. So here we have a man who fathers a child out of wedlock while in high school and is ordered to pay child support, but he falls behind on the child support payments. He then wishes to get married, but the marriage license is denied to him because state law prevents any parent who has a minor child not in their custody from marrying, getting married, remarrying, unless the child support payments are up to date. So, thinking in mind both Loving versus Virginia and the facts of the Zablocki case, we should think a bit here about what we do with the right to marry. And this is something I'll hope to talk to you all about when we have our Zoom class discussion, and think through our test here about whether or not the right to marry should be considered to be a fundamental right. So first we have that key question, which like I said is the million-dollar question: is the right to marry a fundamental right? Therefore, a constitutional right, one that the Supreme Court can and should both recognize and protect against government intrusion into that decision-making process. So I think I'll set that question aside for now, and hopefully we can talk about that some in our class discussion. Having concluded that we have a fundamental right, as the court has done, we have the rest of the test to go through, including whether or not the right has actually been infringed. You could make arguments that perhaps it is not. For example, no one is telling, you could say Zablocki, that he can't get married. They're just saying he has to pay up on his child support before he can get married. But people in Loving can still get married. They just can't get married to each other. They can only marry either another white person or another non-white person. And then we would take a look at the justification for the law. With the Zablocki case, the state would argue that their goal here, their purpose, their justification for putting this limitation on the right to marry was to protect children, to ensure that they are getting the child support that they are due, and that this was an opportunity for the state to try to collect that payment. And then, of course, we would do the means ends testing. We would ask whether or not the justification for the law in the Zablocki case of protecting children, whether or not we have a reasonable law that was furthering a legitimate state interest if we were on a rational basis scrutiny, or whether this law was necessary to further a compelling government interest. So the court tells us that the right to marry is a fundamental right. So the next right we are going to consider then is continuing to sort of think about these issues of family autonomy, the rights to make sort of these personal, intimate choices without government interference, is to think about the issue of the right to custody of one's children. Sometimes this is also broadened to be sort of custody and control, or to make decisions relating to your children. So we have here in the reading on page 981, the Stanley versus Illinois case. This one's from 1972. It's the clearest example of the court talking about the right to have custody of your children as a fundamental right. So in Stanley, we have a couple who's not married, but they live together and they have 3 children. But the mother of the children dies, and the children are taken from their father because their parents weren't married. And the court says that the father has custody rights and therefore is entitled to having a hearing on his fitness as a parent before the children can be given up for adoption. So this case shows us not only how we have a blend of both due process issues and equal protection clause issues, but also we see here a blend of procedural due process and substantive due process, which definitely happens at times. So we could potentially, and the court discusses this case both as an equal protection clause issue and saying that the state is treating fathers who were not married to the mothers of their children differently than they are teaching fathers who are married to the mother or were married to the mothers of their children. So that would be an equal protection issue. The state is dividing people into 2 different groups and treating them differently. But the court also talks about it as a due process issue, simply the idea that the right to have custody of your children is one of the, quote, basic civil rights of man, that this is a fundamental right that we all have, and it is recognized, therefore, as this liberty interest under the due process issue. We also have here a blending of the procedural due process and substantive due process. So on the one hand, this is an issue of procedural due process because the question is about whether or not this man should get a hearing on his fitness as a parent before the children are given up for adoption or allowed to be adopted by the state. But we also have this underlying substantive due process question in that the court is asking what possible reason would the state have in separating children from their parents? And what possible reason would they have to do that without at least first having a hearing on the parents' fitness to raise those children? So continuing on with the idea of fundamental rights of custody of children, of your children, or the rights of fundamental right of parents to control the upbringing of their children, I wanted to briefly mention a case that I didn't have you read, but I wanted to talk about briefly to talk about Justice Scalia's particular view there on how he thinks we should be considering these issues of unenumerated fundamental rights. So the case is the Troxel versus Gransville case. This is a case from 2000, and it involves a challenge to a statute that would have allowed the paternal grandparents of children to have visitation rights with their grandchildren after the death of their son, the children's father. And the children's mother in this case was opposed to the grandparents having this visitation right and brought a challenge to the state's law on the grounds that this interfered with her fundamental right to control the upbringing of her children. The majority of the court strongly reaffirmed that this is indeed a constitutional right. It is indeed a fundamental right for parents to be able to control the upbringing of their children, to make these kinds of key decisions. But Justice Scalia dissented in that case, and he dissented in part by talking about the issue of whether or not the Ninth Amendment should be interpreted as giving the court sort of an understanding that there are additional rights that people have that should be protected as a constitutional right. And he said that the Ninth Amendment's refusal to deny or disparage other rights is far removed from affirming any one of them. and even farther removed from authorizing judges to identify what they might be and to enforce the judge's list against laws duly enacted by the people. While I would think it entirely compatible with the commitment to representative democracy to argue in legislative chambers or in electoral campaigns that the state has no power to interfere with parents' authority over the rearing of their children, I do not believe that the power which the Constitution confers upon me as a judge entitles me to deny legal effect to laws that, in my view, infringe upon what is, in my view, that unenumerated right. So Justice Scalia doesn't think the court should be recognizing and protecting as a constitutional issue any unenumerated rights. He thinks these rights, to the extent we have them, the ones that the Ninth Amendment discusses, are to be protected by the political branches through representative democracy, through the legislative decisions, through the voters' choices of who to vote for to represent them in our democracy, and not by judges as a constitutional matter. And that's all I have for you on assignment number 35. In our next video, we will continue to talk about substantive due process by beginning to think about the fundamental rights of reproductive autonomy. I will see you then.